Good morning. Welcome to this panel discussion on communications law reform. I am Jennifer Elrod, and I was so pleased to be asked to moderate this panel yet again this year. And although I'm in Texas, I don't deal a lot in telecommunications work. I've done this a couple of times, and I said, well, now that you've got the net neutrality and the spectrum auctions and all those things resolved and fixed, what is there going to be to talk about this year? But I learned quickly that even though the technology may move quickly, the law often doesn't follow. And in fact, that is what this topic is about today. As you may know, the technology and communications sector represents approximately 1/6 of our nation's economy. Despite the overall state of this economy, the industry continues to foster innovation, create jobs, and promote economic growth. This highly competitive industry is undergoing a transformative convergence of previously distinct industry areas: media, wireless, and wireline. Yet the agencies that oversee the industry remain guided by stovepipe regulatory principles developed in the 19th and 20th centuries. This legacy legal regime has prompted calls for a comprehensive reexamination of the legal and regulatory structure facing the industry. Our panel will examine how the FCC and the FTC and other government agencies, both national and international, should or should not regulate the communications industry and explore possible avenues for reform. Delighted to have an all-star panel today. We just absolutely have an all-star panel. And I'm going to make introductions now of the panelists in the order that they will be speaking for their introductory remarks. Then they will give brief introductory remarks. The panel will have a discussion, and then we will conclude with questions from the audience. So that will be our format today. Our first speaker today is a repeat player, the Honorable Robert M. McDowell. Robert M. McDowell was first appointed to a seat on the FCC by President George W. Bush and unanimously confirmed by the Senate in 2006. When he was reappointed to the commission on June 2, 2009, Commissioner McDowell became the first Republican to be appointed to an independent agency by President Barack Obama. He was unanimously confirmed by the Senate on June 25, 2009. During his time at the FCC, he has worked to help consumers in the communications marketplace enjoy the benefits of more choices, lower prices, and useful innovations through increased competition. He brings to the FCC approximately 16 years of private sector experience in the communications industry. He graduated cum laude from Duke University, has a law degree from the College of William and Mary, and he formerly practiced at the national law firm of Arter and Haddon. But the thing I like most about him that I learned in my research is that Commissioner McDowell has deep Texas connections, and that his grandfather, I believe, was a judge in Val Verde, Texas. And having been a former state judge in Texas myself, I feel like that makes us connected. So, our next speaker today is the Honorable Ajit Pai. Ajit Pai was nominated to the FCC by President Barack Obama, and on May 7, 2012, he was confirmed unanimously by the United States Senate. On May 14, 2012, he was sworn in for a term that concludes on June 30, 2016. His focus is on creating a regulatory environment in which competition and innovation will flourish to the benefit of American consumers. He specifically works on projects to remove uncertainty that can deter businesses and investors from taking risk, to revisit outdated regulations, and to set clear, modernized rules of the road. He also has a priority to increase promptly the availability of spectrum for high-value uses. He has been shaped by over a decade and a half of experience in communications law and policy. He has served in the FCC's Office of the General Counsel, serving most prominently as the Deputy General Counsel, and his career has truly been expansive, and he served in all three areas of the federal government, in the DOJ, on Capitol Hill, as the Chief Counsel to the Senate Judiciary's Subcommittee on the Constitution, Civil Rights, and Property Rights, And my favorite thing on his resume is that he was once a law clerk to the Honorable Marty Feldman, a wonderful judge in our Fifth Circuit. So Commissioner Pai received a BA with honors from Harvard University in 1994 and a JD from the University of Chicago in 1997. We're delighted to have you join our panel here today. And then we move to the first of our professors today. We have Professor Daniel Crane. Professor Daniel Crane teaches at the University of Michigan Law School, contracts, antitrust, and intellectual property, and various advanced antitrust courses. He was previously a professor of law at the Benjamin Cardozo School of Law and a visiting professor at New York University Law School and University of Chicago Law School. In the spring of 2009, he taught antitrust law on a Fulbright scholarship in Lisbon. His recent scholarship is focused primarily on antitrust and economic regulation, particularly the institutional structure of antitrust enforcement, predatory pricing, bundling, and the antitrust implications of the various patent practices. Professor Crane's work has appeared in the University of Chicago Law Review, the California Law Review, the Michigan Law Review, and the Cornell Law Review, among others. He's the author of several books on antitrust law, including The Institutional Structure of Antitrust Enforcement, published in 2011. Thank you, Professor Crane, for joining us here today. Our other professor today is Professor Jonathan Baker. Jonathan B. Baker is a professor of law at American University, Washington College of Law, where he teaches courses in the areas of antitrust and economic regulation. He served as the chief economist of the FCC from 2009 to 2011 and as the director of the Bureau of Economics at the FTC from 1995 to 1998. Previously, he worked as a senior economist on the President's Council of Economic Advisors, special assistant to the Deputy Assistant Attorney General for Economics in the Antitrust Division of the Department of Justice, an assistant professor at Dartmouth's Amos Tuck School of Business Administration, an attorney advisor to the acting chairman of the FTC, and an antitrust lawyer in private practice. He is the co-author of an antitrust casebook, past editorial chair of Antitrust Law Journal, and a past member of the Council of the American Bar Association section of Antitrust Law. He has a JD from Harvard and a PhD in economics from Stanford University. And next, we have our other commissioner. We're delighted to have her joining us today, the Honorable Maureen Ohlhausen. Maureen K. Ohlhausen was sworn in as a commissioner of the FTC on April 4th, 2012, for a term that expires in September 2018. Prior to joining the commission, she was a partner at Wilkinson Barker Nauer, where she focused on FTC issues including privacy, data protection, and cybersecurity. Commissioner Ohlhausen previously served at the commission for 11 years, so it was like coming home.
Absolutely,
yes. Her positions there included Director of the Office of Policy Planning from 2004 to 2008, where she led the FTC's Internet Access Task Force. She was also Deputy Director of that office. Before going to the FTC, or coming to the FTC, I should say, she spent 5 years at the U.S. Court of Appeals for the D.C. Circuit, serving as a law clerk for Judge David B. Sintel and as a staff attorney. She also clerked for Judge Robert Yock of the U.S. Court of Federal Claims. She's a graduate with distinction from George Mason University School of Law and with honors from the University of Virginia. Thank you for joining us. Let's get right to it. They don't want to hear any more from me. They want to hear from you, Commissioner McDowell.
Well, thank you. It's great to be here. Thank you to the Federalist Society for having us. Can everyone hear me? Is this on? Attention Kmart shoppers? Okay. Saturday morning. I do feel as if, Your Honor, I should start off with you here by saying, may it please the court, but I will skip over that. So there's a lot to talk about today, and I believe the deal was I would focus on sort of international regulation or potential international regulation of the Internet. I have a sneaking suspicion that Commissioner Pai is going to talk about some things that I will just give him a blank check that I agree with whatever he's about to say. I'll be shocked if that's not the case. We do have a lot of work to do here domestically as well, so when we open it up to a fuller discussion, happy to chime in on that as well. But I only have 5 minutes and now only 4, so I better get going.
But who's counting?
That's right. Well, you
I
are,
am.
probably. Exactly. For those who don't know, there is something called the International Telecommunication Union. It used to be the International Telegraph Union. We call it the ITU, but it was founded in 1845 or 46 to adjudicate the termination charges of telegraphs from one country to another, telegraph messages. It has since evolved and is always looking for a new mission. So with the invention of the telephone, it then administered international telephone rates. It to this day also, it's a treaty-based organization, by the way, that operates under the auspices of the UN. So you can call it quite accurately an arm of the UN. It's based in Geneva, but it also administers things like satellite orbital slots, some international harmonization of spectrum, the uses of spectrum, things like that. But there's been a movement afoot for about 10 years to expand the ITU's jurisdiction or maybe to create a new international body through the UN to regulate the internet. I'm not making that up. That is not a black helicopter conspiracy theory. It is actually the truth. And there is a treaty that starts in 2 weeks in Dubai. It starts on December the 3rd. It's called the World Conference on International Telecommunications, WCIT, WICIT. And for you cricket fans, I know that has a different meaning. But we call it the WICIT. And by the way, there's a famous wicket player named Ajit Pai. You know that, right? He's world famous. If you Google Ajit Pai, you're not going to see his face first. You're going to see this. You're going to see the other guy. So,
my father's chagrin, yes.
Yes, right. That it's not you, or that the family name is.
Well, that is not me. He's a big cricket fan.
Oh, okay. But he's famous. He's a big deal. Yeah. So anyway, as is Commissioner Pai, by the way. In fact, Commissioner Pai has done such a great job thus far at the commission that Hollywood has already released a movie about him. It's called Life of Pi. So if you've seen the trailers for that, but that's a different story altogether.
Do you put up with this?
Welcome to my world.
It's part of the freshman hazing we have at the FCC now. On December 3rd, 193 countries will convene in Dubai for this wicket and to renegotiate a treaty that was agreed to back in 1988. This treaty, to make a long story short, really set the stage for governments, international governments in particular, but governments keeping their hands off of emerging technologies and computer-to-computer communications as they were known back then, or what later became the internet. I think most people will agree that the internet works quite well without the government's help, and that governments don't work so well. But unfortunately, there have been, over the past 10 years, a number of efforts and a number of international meetings where countries, I'll say China and Russia, but the Arab states, a lot of developing world nations, Iran, Cuba, and others, that have been pushing for more international oversight. Brazil and India as well. In fact, India, about a year and a half ago, introduced a resolution on the floor of the UN for there to be a new regulatory body under the auspices of the UN just for purposes of regulating the internet. And the motivations for this are numerous. They're economic. There are some countries that see the internet dominated by American companies sitting on piles of cash. A lot of developing world nations and even industrialized world nations, phone companies are either state-owned or partially state-owned. And so they see an opportunity to charge maybe on a per-click basis or other basis for international web traffic. If you go to a certain web destination and you're in that country, it would flow into, the cash would flow into the treasury ultimately of that country. So economic. And then certainly there are a lot of authoritarian regimes that are supporting international control of the internet for political purposes. And hopefully I don't need to explain that, but they fear the free flow of information across the net because it could lead to their demise if they're a despot. So there are a number of motivations out there. The concern is that we now have, as of November 13th, a number of proposals in black and white. So cutting to the chase, after months of chatter and rumor and all the rest, we now have formal proposals from member states, from countries, before the ITU to do just that, to have the ITU regulate the internet. So the most recent that came out is from Russia, and this is a copy of it translated into English, and it quite literally expands the definition of the ITU's jurisdiction to include the internet and processing and IP addresses and who has on them right now a wireless device. I figured that'd be the case. Okay. Well, and who can send an email or email from that wireless device. Okay. So each of those devices have something called an IP address that tells other people and their computers where to send, where you are and how does that get to your device. So Russia and the Arab states and others have proposed that the ITU manage IP addresses. Well, that reaches into every web-connected computer chip in the world, and there are billions of those. So what is troubling, and I'll try to end on a more positive note, but is the leadership of the ITU itself. So there are these offices in Geneva. We pay dues just like we do to the UN, and that supports the ITU. And they have employees, and there are officers of the ITU, so a CEO we call the Secretary General, and others. They are supposed to be serving the member states of the ITU. They've just recently put out on November 15th, so 2 days after the Russian submission and 2 weeks after the Arab states submission on November the 1st, and other countries as well, they posted a blog, which is a little unsettling, as if the rest of this isn't unsettling, but this is even more unsettling. I'm quoting, despite what you may have been led to believe, there have not been any proposals calling for a change from the bottom-up multi-stakeholder model of internet governance to an ITU-controlled model. That's just flatly false, unless 2 days after the fact they hadn't read the submissions, or 2 weeks after the fact they hadn't read the submissions that were submitted to the ITU. These submissions are in plain black and white. There's no ambiguity. It's not over-reading. So the good news is that they went on to say internet control is simply not in the ITU mandate, and ITU will continue to fully support the multi-stakeholder approach, which it initiated some 10 years ago for the World Summit of the Information Society. WCIT 12, the upcoming meeting, cannot empower governments to exercise greater regulation of the internet. But what's unsettling here is the first sentence. And there's been a habit that we've seen of ITU leadership saying one thing to one crowd and another thing to another crowd, or sort of denying the reality of that, no, there are dozens and dozens of these member states that are proposing these ideas. So as our delegation goes to Dubai, they have behind them, they've been sort of fueled by a rare thing in Washington, and that was a bipartisan and unanimous consensus of both houses of Congress, resolutions that were introduced in both houses of Congress, directing them to not agree to one single expansion of ITU, a jurisdiction, into the internet space. So that gives me some confidence. At the same time, ITU leadership has been saying that they will try to continue into the tradition of the ITU to make sure that the WCIT negotiation is done through consensus and unanimity, that there will be no changes unless all the countries agree, which probably means that what will come out of it will be these high-level, almost platitudes regarding internet deployment is good, infrastructure deployment is good, et cetera. The concern, though, is that some of the proposals made when things really, when we get down to brass tacks and the negotiation really starts, is that there are a lot of seemingly innocuous reasons that sort of wrapped around more nefarious proposals. It might be internet infrastructure deployment. It might be keeping children safe. It might be a lot of issues that are used as sales pitches to then give the ITU a hook into this space. And there are some countries that are already saying that the ITU currently, under the 1988 language, already has jurisdiction over the internet. So if these same sort of aggressive expansionists are willing to sort of conjure false meaning from plain text, when that meaning is obviously not there, think of what they'll do if you give them even the tiniest leverage point with expanded language, and even if it's just sort of a high-level agreement on a principle. So that is one concern I have. And also the other concern at the outset is that obviously ITU leadership, the career folks leading this meeting, have a point of view. And they're not really supposed to have a point of view. They're supposed to let the membership decide. The good news is that this is a treaty, that if the State Department, and that State Department leads these negotiations, what they bring back has to be ratified by the U.S. Senate. I don't think, despite election results, I don't think the U.S. Senate would pass or ratify a treaty that has any expansion of the ITU's jurisdiction into this space. There seems to be great unanimity on that, and Congress is trying to celebrate those areas where it can agree. So that's all good. But then it's not over. So I said at the outset, this has been going on for about 10 years. There's another meeting in May. And there'll be several meetings a year for the rest of our lives. And so when the gray hair turns white, we'll also be talking about this. And so I think it's important for us all to remain vigilant about this, because the folks pushing for this are patient and persistent incrementalists. And that is ultimately freedom's biggest threat, is the incremental erosion of it. It's not going to happen in one big gulp. Of course, you can't buy a big gulp in New York City, but that's another matter. Speaking of freedom. And soon Chicago. Oh, really? So, well, should have guessed. I'm amazed San Francisco wasn't first, actually, with this idea, but I think they're jealous. This isn't alarmist. This is not black helicopter conspiracy theory. The last thing I'll end on is, at a minimum, the destruction that comes out of this isn't that the U.S. will agree to a treaty that we're giving the UN control over the internet, is that it could create uncertainty in the marketplace. The internet is a global network of networks without borders, and of course the content and the applications are all part of that. But from an engineer's perspective, you don't see countries there. It's a network all over the globe. And when you send an email, those packets, those ones and zeros, are being routed all over the world, and you don't know where they've been by the time they show up to their intended destination. And you can't really have a bifurcated or balkanized internet. So even if we are able to escape the Dubai conference with freedom intact, should there be a strengthening movement for more regulation, and as it usually works, is that you end up sort of negotiating against yourself, right? They maintain, well, here's a rule. Why can't you walk down this road of rules? Just take a step down this road, and before you know it, you're running down the road. But it can raise costs, and it can undermine innovation and investment just by having the uncertainty there. So I hope you all will continue to be aware of this, and we all need to continually, for the rest of our lives, stay active on it and make sure it doesn't happen. Thank you.
Commissioner Pye?
Thank you, Judge, and thank you to the Federalist Society for inviting me to participate. I want to start by commending my colleague, Commissioner McDowell, for flagging this issue. He did so before virtually anybody else in Washington, and I'm confident that as the treaty negotiations heat up, he will continue to be an eloquent voice in favor of the multi-stakeholder model that has served us and indeed the world citizenry so well. The central question that he and others at the ITU are going to be struggling with is, what is the role of government in a world that is based essentially on the Internet protocol? In an all-IP world, in other words, does regulation have a role? And in answering that question internationally, it becomes ever more important that we get that answer right domestically. And so in my comments, I'd like to focus a little bit more on the domestic side. And I think Judge Elrod eloquently put it in her question: how does the Commission, the FCC, administer the Act in an era of convergence? This is becoming increasingly difficult, as I have unfortunately had firsthand experience. So, when I started in this field in 1997, interpretation of the Communications Act was relatively simple. If you had a telephone issue, well, you just go to Title II of the Communications Act. If there's a wireless issue, you turn to Title III for guidance. If it's a cable or other kind of video issue, you turn to Title VI. And back in 1997, when I was starting, it was relatively easy to pigeonhole an issue within one of those titles. But how do you administer the Act when cable companies and wireless companies are providing the same voice service that telecommunications companies did? How do you administer video regulations when telephone companies and wireless companies even are competing with cable companies? In an era of convergence, it becomes really difficult for us at the Commission to try to figure out how to apply these regulations. And that unfortunately requires the FCC in recent years to engage in ever more sophisticated legal gymnastics. And having been a veteran of the General Counsel's office, I can say I was one of the participants in that effort. And part of the problem is illustrated, for example, by our use of what's called the ancillary jurisdiction doctrine. This doctrine had its origins in a 1968 Supreme Court case called Southwestern Cable, in which the court affirmed the FCC's decision to expand its jurisdiction, even though it didn't have explicit statutory authority. The court said, well, as long as what the FCC is doing is reasonably ancillary to the Commission's statutory responsibilities, it can go ahead and do it. And similar to in the constitutional context, you have the substantive due process issue where what is substantive due process is in the eye of the beholder. Over time, if we have a convergence and the Act doesn't clearly speak to what the Commission's jurisdiction is, there's always going to be a temptation among those with a more regulatory instinct to apply ancillary jurisdiction to say, well, even if we don't explicitly have authority, it's sort of kind of related to what our responsibilities are. And so in some cases, although ancillary responsibility or jurisdiction might well be reasonable, there are all too often issues where the Commission is relying upon it and hoping that it survives a petition for review in the DC Circuit. And that's, in my opinion, not the way it should be. My view is that we should administer the Act the way it is, not the way we wish it should be. And unless and until Congress decides to revisit the provisions of the Act, our job as regulators is to simply interpret it as Congress passed it. And so the question is, well, where do we go from here? And I think as we undergo this transition from an era of copper wire networks dominated by monopolies to an all-IP world in which you have competitors engaging in massive amounts of investment in terms of intermodal competition, my opinion is that we should leave behind some of the outdated economic regulations that characterized policymaking in the 1970s and move to a more forward-thinking view of what regulation should be. And just to give you an example of why that is important, just contrast for a second the way we approach wireline regulation, telephones, to the way we approach wireless regulation. The wireline regulations, which as I mentioned arise from Title II, were themselves crafted based on railroad regulations that were adopted in the 19th century. And so, you look at the wireless space by contrast. In 1993, you had Congress and the FCC making a historic bipartisan decision that they were going to take a different approach to wireless. It was going to be a very light touch. The FCC and the state and local jurisdictions were not going to have as much authority to intervene. Wireless service would not be a common carrier service as telephone services. And what's the result? Well, back in the early 90s, when your only option was a wireless phone that was a brick and very few people were able to afford it, all of us now, as the Commissioner pointed out, have wireless phones. We all count on functionality and prices that allow us to enjoy those services. But just imagine for a second what would have happened if we applied the wireline approach to wireless. You would never get a nationwide rate plan because every single wireless carrier would have to abide by both federal regulations and the regulations of every single one of the 50 states. A wireless carrier couldn't subsidize your phone without taking the risk that it would also have to subsidize a competitor who wanted to offer a phone. A wireless company couldn't upgrade its network or take the risk of upgrading its network without hiring an accountant to keep track of all the regulated costs and then submit detailed cost studies to the FCC so that we could look at the books and make sure that they were doing the right thing in terms of investment. That's the kind of approach that would have stifled the wireless industry at the inception. And so my own opinion is that whether it's wireless or even other kinds of intermodal competition, voice, video, what have you, We need to take a more deregulatory approach, the wireless approach, if you will, as opposed to the wireline approach. And so whether in the context of an industry-wide rulemaking or within the context of a transactional review, which my colleagues on the panel will talk about, I think that the FCC needs to think creatively about establishing a framework domestically that will be more hands-off, that will allow the all-IP world to flourish, and ultimately for consumers to be better off. So I look forward to the discussion from my colleagues about how transactional review in particular can help facilitate that goal. And I once again thank you, Judge, for moderating, and the Society for inviting me.
Thank you. Professor Crane?
So I'm going to stand. John Baker and I agreed that as professors, it's against our grain to be seated, and also if you want to stir up some kind of controversy or argue in the room, it's better if you start on your feet, and I think that's what John and I would like to do. It's what we usually do when we're together or apart. I'm, again, really delighted to be here, and want to thank Judge Elrod and the other panelists for this wonderful opportunity to address some interesting questions. The question I want to talk about is the overlapping jurisdiction of the FCC and one of the antitrust agencies, which almost always means the Department of Justice, although it could be the FTC under some circumstances, to review mergers in the telecom space. So today, mergers within the jurisdiction of the FCC have to be approved by the FCC and have to be notified to the Justice Department under the Hart-Scott-Rodino Act and effectively cleared if they're going to proceed. And the question is whether it makes sense to have this kind of dual review, or if we're thinking about reform of the telecom regulatory space on a forward-going basis, should we think about a different kind of arrangement? Before getting into the nitty-gritty, I just want you to ask yourself, from an institutional design perspective, what does it suggest when you have two separate institutions that have to approve something? So think about bicameralism, for example, and this being the Federalist Society after all, we can think about the constitutional design. The fact that new laws have to pass both the House and the Senate, of course, makes it harder for new laws to pass and to become effective as the law of the land, as compared to, say, a parliamentary system where a single chamber has to decide on new laws. Of course, the framers of our Constitution were well aware of this, and in fact, they justified the difficulty of getting laws past two chambers or two houses of Congress as an important aspect of the preservation of liberty, since it became harder to legislate. Now, of course, when the question is not whether new laws should be passed, but whether a merger should be allowed, and you have a dual review model in place, the dual review model is not creating protections for freedom, but higher obstacles to getting business deals done. So just for example, in the recent AT&T T-Mobile transaction that some folks on this panel may have had something to do with, it's almost certainly the case that AT&T had a much harder time, a much harder battle in persuading two agencies at once to clear the deal than it would have had if it had only faced one of the agencies. And of course, AT&T T-Mobile, that deal fell through because of the opposition of both agencies. Now, again, I'm not suggesting that the decision was necessarily wrong, just to point out that if you're looking at structure of agency decision-making, having to go through two agencies is, of course, more difficult than just going through one. Now, you might not be motivated to care about this unless I could tell you a story about lots of good deals facing a sort of a systematic obstacle to completion that sort of justifies the view that we have excessive regulation because of dual agency review. Of course, the problem with making that claim is an endogeneity problem. The mergers and acquisitions that get proposed are the ones that smart telecom lawyers and reasonable business people reading the regulatory landscape think have a high degree of likelihood of getting approved given dual review. So it's not surprising that we see relatively few cases like AT&T T-Mobile where the deal is completely disallowed. Smart lawyers and business people will avoid bringing these kinds of mergers in the first place. What we do see, on the other hand, is lots of deals that are ultimately approved subject to extensive conditions imposed by both agencies. So these can be divestiture requirements and or conduct commitments such as non-discrimination or compulsory licensing of various kinds, just to give some examples. When you look at the overall pattern of dual review in the last few decades, a general pattern emerges. In very few cases do you see both agencies requiring exactly the same relief in terms of conditions or commitments. Most of the time, you'll see an overlapping core, right? Both agencies agreeing on some common set of conditions necessary for the merger to proceed, with a number of extras on one side or often on both. So for example, you'll see the FCC requiring divestitures in 7 markets and the DOJ requiring divestitures in 8 markets, or the FCC accepting all the conditions in the DOJ consent decree, but adding a list of additional conditions or divestitures. So for example, in the AT&T Bell South deal, one of the conditions imposed by the FCC was that 3,000 jobs that were currently outsourced outside the United States be repatriated to the United States. Now, one response is that this is just a product of the separate statutory mandates, the FCC having a broader public interest mandate than the DOJ, which only looks at competition issues. But again, that would suggest that the pattern would always be the FCC requiring more than DOJ, and sometimes there are cases when DOJ, in fact, requires extra things that the FCC does not require in its conditions. Just looking at a spreadsheet of dual review cases over the last few decades, one certainly gets the impression that each agency wants to be able to claim and extract some extra goodies out of merger review. Indeed, if both agencies were extracting exactly the same proverbial pound of flesh, then what would be the point of having 2 agencies? But that, of course, begs the question, what is the point of having 2 agencies reviewing the same transactions? Of course, the problem also gets worse than this. It's not just that the 2 agencies extract different pounds of flesh, it's that sometimes they make inconsistent demands on the merging parties. For example, the DOJ, looking at antitrust principles, generally wants divestitures sort of divested assets be sold to buyers that are firmly established in the market in order to ensure that the divested assets play a meaningful role in checking the merging firm's market power. By contrast, the FCC has often pushed for divestitures to smaller players or new entrants in order to foster greater diversity of voices in the marketplace. So the parties making a decision about seeking a merger or an acquisition have to worry not only about the prospect of running the gauntlet of 2 different agencies reviewing their transaction and each extracting their own pound of flesh, but also that the agencies may make inconsistent demands which can slow down or complicate the process of getting the merger approved. So then what's the solution? Well, the core of my view is that we should think about the possibility of giving only one agency jurisdiction over mergers in this space, but perhaps allow the other agency an advisory function, as is true of the Justice Department's advisory function in certain categories of bank mergers, where the actual decision is made by a banking regulator, but DOJ plays an advisory function. If we were to go this route, the question is which agency, of course, and I'm not firmly committed to a view on this. I just sort of think out loud a little bit. One thing that the FCC has, as I said before, is a broader statutory mandate. If we think that the public interest mandate of the FCC is important in the telecom space, and that is broader than simply achieving competition and efficiency, then it makes sense to have the FCC taking the lead since it has a more comprehensive mandate that also subsumes in some sense the mandate of the DOJ. On the other hand, and reflecting now some of the comments, particularly by Commissioner Pai about technological convergence and changing industrial segments. So for example, we think that the distinction between pipes and content is too sharp, and that in some sense transmission or pipes and content are lines that are less important than they were years ago. Then that really suggests that there are segments outside of the FCC's jurisdiction and within the DOJ's jurisdiction that would need sort of common supervision by a single agency, at which point the argument would be that we should have a single competition law framework to address telecom mergers, as is true of sort of adjacent spaces not within the FCC's regulatory jurisdiction. So for the time being, I'm agnostic on the solution, but firmly committed to the view that there is a problem in need of discussion. President Obama, who I understand has been reelected, has previously spoken in favor of eliminating regulatory review by multiple agencies, about eliminating duplication in agency jurisdiction, and in streamlining regulatory processes. So my question is, why not here as well? Thank you.
Thank you very much. Professor Baker, why not here as well?
Thank you, Judge Elrod, and I'm delighted to be here and on a panel with so many distinguished colleagues from agencies and academia. I mostly want to react to the issues that Dan raised. Dan mainly seem, well, or at least he toys with the idea of giving the FCC exclusive jurisdiction over competition issues that arise in communications industry mergers. And it's worth noting that this is, he's not alone in seemingly preferring, or at least considering preferring, you're agnostic ultimately, I guess, economic regulation over competition and antitrust enforcement, because that echoes how the Supreme Court came out twice during the past decade in both Trinco and Credit Suisse. And before that, and this, the critics of concurrent jurisdiction invariably took the other side that Dan somewhat sympathetic to, of giving exclusive jurisdiction to the antitrust enforcement agencies on the view that preferring antitrust would be the more deregulatory approach. Well, what I want to argue for this morning is preserving concurrent jurisdiction as likely to lead to the best results in merger review. Because that approach takes advantage of the complementary strengths of the sector regulator and the antitrust enforcement agency. So I want to sketch first a couple of advantages of the FCC in merger review in communications transactions. One of them is communications industry expertise, so both in terms of how the industry works and how the regulations that are in the background operate. So in the AT&T T-Mobile merger review, the FCC's engineers were an invaluable resource for evaluating the potential efficiencies, and it was invaluable not just to the FCC, but also to the antitrust division. They provided analysis that was both reliable and independent of any of the parties to the merger, and the agencies needed that. In the Comcast-NBCU transaction, the FCC's expertise on how its program access rules operate was critical for both the FCC and the Justice Department in fashioning a remedy. But aside from communications industry expertise, the FCC has another advantage, its greater ability in practice to address potential competition issues. These can be important for evaluating mergers in fast-moving markets. The competition agencies have trouble protecting potential competition when they challenge mergers in court, because generalist judges, like our colleague here, don't have prior industry expertise, although I don't really know whether you have communications expertise. So I'll take that back if perfect. But generalist judges, most judges don't have that kind of expertise, or may not be able to evaluate predictions about how the industry will evolve very easily, and might view them as speculative, while the communications agency may have a greater understanding of how the industry works. And the antitrust agencies, on the other hand, have complementary advantages in merger review, which is why you want them involved as well. One is their competition expertise. They understand how to evaluate competition issues because they do it all the time. And another is their greater practical ability to obtain information about the industry. And there's a larger issue in that. Sector regulators are commonly, or at least historically, have often been thought to be prone to agency capture. I don't mean to say that they are all necessarily and always captured, but there's definitely been a concern about that. By which I mean coming to favor the industry, the interests of the regulated industry over public interest concerns, for example, protecting competition. And I don't think the problem with capture is political influence, because if Congress, pushes an agency to favor industry interests over the public interest, then the captured body is Congress, not the agency. And I don't think it's the revolving door, because that mainly operates to bring good people into the agencies and often keep them there. But when there's a problem of industry capture, and this is consistent with the economics literature on the subject, it generally comes from the ability of the industry to manage information. So the FCC has all this engineering and economic expertise, but it only goes so far without data. And the competition agencies, on the other hand, get more information using compulsory process in merger review than the FCC can obtain through its routine data collection that's going on independent of the transaction reviews, or its own use of compulsion, particularly in a political environment where FCC information requests are questioned as imposing unnecessary burdens on industry. That question doesn't come up with the antitrust agencies because they're seen as doing law enforcement. And when reviewing mergers, the FCC staff cannot do what the DOJ and FTC staff routinely do, which is call up customers or learn about what to investigate from industry participants who are not eager to make submissions on an adjudicated record, because it's a formal adjudication when you review a merger at the FCC. So Dan raises two concerns about concurrent review, and I'll end by commenting on those. Dan worries about over-regulation, but I would say that concurrent review leads to better regulation because the two agencies can share their expertise in complementary areas, and what the antitrust agency learns can generally be brought into the FCC's adjudicated record. So, and Dan's other concern is with the costs of coordination, but my experience from working on merger reviews that were both simultaneously looked at by the FCC and the Justice Department is that this concern is largely theoretical, that the Justice Department and the Federal Communications Commission had no trouble coordinating merger reviews in either Comcast NBCU or AT&T T-Mobile, including harmonizing relief in the Comcast matter. And one reason that happened, by the way, is that that coordination was so successful is that the FCC's chairman and the Assistant Attorney General had selected senior staff who knew each other and knew how the other agency worked. And I think that experience shows there's no inherent problem with coordination, and that the concern is really more hypothetical than real. So let me just stop my defense of concurrent jurisdiction here and let Maureen talk about how communications regulation looks like from the perspective of an antitrust agency, or really an antitrust and consumer protection agency. So thank you.
Commissioner?
Thank you. As a sitting commissioner, I'll join my other sitting commissioners. I'll be seated during my remarks. But thank you, Judge, and thank you to the Federalist Society for having me here today. I'm delighted to be part of this panel. So, building on what a number of the other panelists have said, I wanted to talk a little bit about what is the right approach in an area for government regulation in an area where markets and technologies really are converging. So to give you a little background about the FTC, we have a very broad statute, Section 5 of the FTC Act, unfair and deceptive acts or practices, inter-affecting commerce and unfair methods of competition. And that's allowed us to be very flexible over the years throughout a number of industries in enforcing both the consumer protection and antitrust powers. And I think that that model also fits today's very convergent communications environment very well, rather than sort of the siloed approach that Commissioner Pai had talked about previously. One of the small challenges to this is that the FTC still has a common carrier exemption in its statute. But I kind of look at that as an island that the river has really started to go around, because so few services are now considered common carrier services.
Oh, just wait.
Yeah, well, and I also put in the caveat that the FCC's interpretation of whether something is a common carrier doesn't necessarily control the FTC's jurisdiction, but
So there.
it's certainly one of those factors that I'm sure a court would consider. But that's one of the reasons why a few years ago the FTC started the Internet Access Task Force that I headed up, and we looked at the issue. It involved net neutrality at the time, and the question was, given the movement towards so much being over the internet, were special rules needed to require, non-discrimination on the internet, open access, the internet freedoms kind of issue. And as we looked at it as an agency, we came to the conclusion in a report we issued in 2007 that said, while there is the potential for problems to develop, it seemed that the traditional tools of antitrust and consumer protection could address these problems. Antitrust is very well suited to look at exclusionary conduct, discriminatory conduct, and that the consumer protection role can't also be overlooked. A lot of these issues involve if a lot of the theories of what the problems would be involve, did a consumer signed up for a broadband service and then they weren't getting what they were promised, whether it was speeds or whether it was certain content that was disfavored. Well, that's a very traditional consumer protection kind of issue. And if a provider had made a promise and then didn't live up to it, You don't need a new and special rule to address that. We have Section 5 of the FTC Act. So we've looked at that. And so that was our recommendation, is kind of taking a wait-and-see approach, particularly because, I have actually a quote here, in evaluating whether new prescriptions are necessary, we advise proceeding with caution before enacting broad ex-ante restrictions in an unsettled dynamic environment. And I don't think that advice has really changed in the past 5 years. I haven't seen something that says, here's the big problem in the market, here's what we should have been, waiting for these problems to develop. I think we've sort of said, well, things seem to be moving along okay. I also wanted to mention, while it is true that the Department of Justice, because of the common carrier exemption, while it's true that the Department of Justice has done much of the oversight in the telecommunications area, the FTC has always shared jurisdiction with the Department of Justice in things like cable mergers and internet and technology in general. So the FTC, I think, is well positioned, along with the DOJ, to continue to play a role here. So pivoting from sort of this general approach to merger review in particular, I do think that Dan and John do bring up some good issues, but the question that I have is, a lot of the issues they're raising are not really specific to the telecommunications industry. There's a lot of fast-moving technology industries that the antitrust agencies have to review, and that I think the antitrust agencies have been able to review pretty well. So telecommunications is hardly alone in being that kind of industry. I also think that having a general non-industry specific regulator or decider in antitrust areas brings a lot of benefits. First of all, I think Dan talked a little bit about predictability for businesses, the hurdle of having to please two regulators. Is that a problem? I think there is a fair amount of predictability in the antitrust review model based on the years and years of experience that we have. We have horizontal merger guidelines. We have, sometimes we have industry-specific guidance, maybe in the healthcare area is a good example of that. But there's a really specialized body of knowledge out there that practitioners are familiar with. I think there is a good likelihood of a quick resolution when we're operating under the Hart-Scott-Rodino Act. There are timelines that we have to meet. There's expertise and procedural tools in developing the factual record quickly and efficiently. And I also think there's a lot of certainty that comes from the narrower standard of review of a substantial lessening of competition. That's the standard under the antitrust laws, rather than the more general public interest standard. The public interest standard is very elastic, and that can vary quite a lot over the years. There's really been a lot of case law, agency thinking and federal case law on what is a substantial lessening of competition. And it's much more targeted to antitrust concerns, competition concerns, and I think that is what accounts for some of the differences in the review, in the relief that the agencies would require between the FCC and the antitrust agencies. The public interest standard, as I said, is very elastic. It could require a lot of different things. Sometimes the antitrust standard may require maybe more divestitures or a different type of oversight. That's, I think, coming from their expertise and what they see as competitive problems that they've seen across time. Also, the question is always, once you impose a remedy, how successful will that remedy be? How well will the divestiture work? What kind of compliance do you have? And the antitrust agencies have those aspects in place. I'm not saying that the FCC doesn't, but the FTC and the DOJ do this all the time. We just reviewed a merger of Hertz and $1.50. Just got approved the other day. Extensive divestitures are required. Lots of compliance required. But that's the kind of thing that over time the agencies have developed a lot of expertise in making sure that, it's not a great outcome if you have a merger challenge, you solve it with some divestitures, but then the remedy doesn't work very well. And I think that the agencies have paid a lot of attention on that, and that may account for some of the differences in the kinds of divestitures that might be required. I recall a number of years ago, and John, you may have been at the FTC when we did this, there was a study of the success of divestitures, and it had some surprising results, if I recall. It wasn't necessarily that the big player, that if you divested the asset to the big player, that it was the most successful. If the small player was most successful. It was actually the medium-sized player, I think, that had the best results in some of the divestitures. So a little bit counterintuitive, but the idea that the public interest standard might have you divesting to a different type of buyer than what an antitrust agency might do is something important to keep in mind. And then just to focus on one other thing about the difference between being a generalist agency, I guess is a better way to put it, versus a specialized agency. So the FTCs and DOJ are very generalist agencies, and we don't see the same players before us all the time. I mean, the FTC, we might see oil, we might see pharmaceuticals, fairly consistently. Well, there's a very wide range of industries that come before us. And so that, I think, keeps the standards a little more general, a little less industry specific in a good way. Because one of the things that I think can develop in an agency, and we see this isn't just FCC oriented. We also see this in, FDA, pharmaceutical companies, where you've got, so many proceedings before an agency that are so important to your company that there is, I think, a concern that outside of one proceeding, so if a company is pushing too hard in one proceeding, the agency doesn't like what they're saying or what they're doing, there is the fear that the agency could take retaliatory action in another proceeding, totally unrelated to the merger, but maybe just as crucial to the agency. So, for example, in drug review, that could be a problem at the FDA. I imagine that similar concerns could arise in the FCC when you're, it's like, well, I have to go back to the same people and ask for my license review, and we have this other proceeding that's very important to us, and so that creates, I think, a dynamic that a generalist antitrust oversight doesn't create. So that's my pitch for the generalist antitrust oversight and the FTC in particular, given our unique blend of both consumer protection and antitrust oversight.
Thank you all for your introductory statements. Does anybody else want to weigh in on the generalist? Do you feel like you need to have a counterpoint, or?
No, I'm happy to get.
You're happy to move along. Well, good. We'll move along. We heard about this international approach in the internet realm, and I bet many people in the audience had not heard about these proposals, and probably a number of people had not even heard that we were a member of this international body, and so I'm sure this is very alarming news to some. But I wonder, would there be some on our panel who might think that the net neutrality rules that have been imposed are just an incremental way to begin our own government's regulation of the internet? And does anybody want to comment on that?
Sure. Real quick. Well, and then maybe both can. So, absolutely. Big concerns there as well. Of course, this is the December 21st, 2010 FCC order on net neutralities before the D.C. Circuit, perhaps one of the longest appeal time horizons in a long time. Hopefully will be decided next year. But there was, no issue that needed to be resolved. The FCC doesn't have the statutory authority to resolve the problem, should there be one. There were ample laws on the books to address any problems as alleged by the proponents of these regulations, if they actually ever existed, which they don't. And some are with the FTC Act or antitrust laws, et cetera. So a lot of problems there, but I've said this before, a couple of things, which is one, it's just another step of government into this space, which is not needed and is actually counterproductive, and it's counterproductive for consumers. And then number two, the FCC launched in the summer of 2010, opened a proceeding called the Title II docket. And you heard Commissioner Pai speak before. Title II under the Communications Act is what regulates monopoly voice phone service. And so internet access, broadband internet access, would be classified as a monopoly phone service. And that's the logic is the same as to what is trying to be done to the internet on the international level. So there are a lot of concerns here. That docket remains open, and after the November 6th election, I am concerned about what will happen when the D.C. Circuit strikes down the FCC's net neutrality order under a different legal theory called Title I and some other stuff they threw in there, and imaginative stuff. And so there's this Title II docket sitting there. What's going to be done with that? There'll be tremendous political pressure from the left for the FCC to classify this piece of the internet under Title II, all with the argument of we'll make it skinny, we'll wall it off, blah, blah, blah. So it's a huge concern.
Oh, sorry.
Do you want to comment?
If I could add just a brief gloss on Commissioner McDowell's comments, with which I associate myself fully. Regardless of how the net neutrality debate goes in the D.C. Circuit, the basic question there is going to continue to resonate, and that question is, does the government have a role in the decisions on network management that a private sector actor makes? In this case, net neutrality is a very high-profile example of that question, but there are all sorts of things flying under the radar now that have come up in the 6 months that I've been at the Commission. Just to give you one example, some of our colleagues at the Commission are now making noises about the impropriety of usage-based pricing. And so a lot of companies, in order to manage network congestion, which is occasioned by the fact that the top 5 or 10% of their users consume 80 to 90% of the bandwidth, are now implementing usage-based pricing so that you pay for what you use. Most of us in the consumer context are very used to this proposition. You wouldn't go into a fancy restaurant and say, I'm going to eat all I can and then pay you a very low price no matter how much I eat. But in this context, people have gotten so used to consuming as much as they want and paying a set price that the Commission is now taking that instinct and trying to internalize it to require companies potentially not to make usage-based pricing a basis of their pricing policy. And that is a sort of a Rubicon, because once you give the government a role in second-guessing the network management decisions that a private actor makes, there's really no way to cabin it, other than relying upon the discretion of 3 or hopefully 5 members of the Federal Communications Commission. So that's another issue to keep aware, to be mindful of. In addition to net neutrality, it's going to bubble up in a lot of different contexts, and we need to keep an eye on it.
Professor Baker?
I actually also wanted to mention one of the things that particularly concerns me on the open internet, the net neutrality requirements, is I believe there's no market power screen, right? So you can have a very small player who is offering a service that doesn't necessarily give full panoply of internet access, and that might be because of bandwidth constrictions or because of technology constrictions, but that wouldn't be permitted. And I think that could be problematic under the order, because it's not that you're excluding a large part of the market or that you're doing something that really could be hurting any particular other content provider, all the things that went into the creation of the network neutrality order, the kinds of concerns, and you are impeding the ability to use assets in a way that might be a higher valued use, like an asset that doesn't necessarily have the full bandwidth, doesn't have the new wide channel, and you're saying, well, this small channel, you still have to offer everything or you violate the order. And I don't see how that makes consumers better off, because that's ultimately what we should be caring about, is this actually going to make consumers better off?
It looks like this is a popular topic, so I think everyone else wants to weigh in. And also, when you weigh in, I'd be interested to hear whether people think it's moot because the technology has changed since the advent of the rules, the idea that people are getting things from the mobile carriers so much. I'd like to hear that as well.
I'm change this topic a little bit, so why don't you go first?
So let me, I seem to be in the position of taking the other side. So I agree that, historically the internet has worked fine. Basically, that there are these little things that, happen that, but basically that, but the question, where I think the big difference between the people who think that there's something worth doing in the open internet order, and that was a good idea, and the people who don't, has to do with the diagnosis. My sense is that the implicit presumption of my colleagues on the panel, let's say, is that the reason that everything has basically been fine in the internet world till now is the absence of regulation. And what I would say is that, well, no, that's not it. It's the absence of discrimination. And that that when you that the and so that that would justify the kind of light touch regulatory approach that the FCC did implement in the Open Internet Order, that just broad general rules about transparency and non-blocking and non-discrimination. Now I don't want to take a position on any dispute that has taken place since the Open Internet Order, and I don't really know the details about it, but just reading that order, there's a lot of sympathy for congestion pricing and the kind of allowing firms the ability to make network management decisions that Commissioner Pai is worried about. And my sense is that the order was never intended to be some sort of across-the-board hostility to network management decisions that address congestion questions. I mean, I could imagine there would be individual cases where there'd be some kind of issue, but I don't know about them. And the other broad picture comment about the Open Internet Order, which hasn't come up here, but I just want to raise it because it does come up, is that people talk about whether it would interfere with investment, and when people worry about that, it's a partial focus. It's on the investment by the platform operators, which is a legitimate issue and one that was considered in developing the rules. But the point of the story of the rules is in part to make sure we also get investment in what are called edge providers in the rules, the people making applications and other kinds of not just the platform itself, but the people developing uses for it, equipment and applications and the like. And then if I could go on and talk about convergence for a second, I largely agree with what Commissioner Pai had to say about the problems that changing technology create for the regulatory scheme. And I want to give a little perspective on it, which is that when I worked, this was before Commissioner Pai entered the communications field, but when I worked in the Clinton administration White House on communications issues, among other things, it was the run-up to the 1996 Act. And I recall a great deal of conversation that we had multiple occasions and a lot of serious thought about it, about whether we wanted to propose a new title to the Communications Act that would deal with bit companies, when the cable companies started to look like the phone company and vice versa. Now, it didn't happen then. There were a lot more pressing issues from the point of view of the industry, for example, that took priority in developing the 1996 Act. But I agree that we're sort of seeing the problem now. But that doesn't mean but what I want to caution is the fact that we're getting convergence doesn't mean that every service is somehow automatically competitive. It doesn't mean that there aren't going to be natural monopoly elements still in that would require regulation. And so one has to look in detail at how the industry is developing and create a regulatory structure that craft one that fits the industry today. But I'm sympathetic to the project of trying to do that, which Commissioner Pai has embarked on.
Professor Crane.
So I just wanted to go in a slightly different direction, which is to say, I think that net neutrality is problematic in principle, but also just be aware of neutrality creep, which is net neutrality is converging into search neutrality, and this is obviously a topic that will be addressed in upcoming days or months in terms of the possible Google case. But there is a general sense in certain quarters that there should be a regulatory neutrality principle that not only applies to providers, but also to search engines and to sort of various spaces on the internet. And my own view is that sort of a general idea that the government has an obligation to mandate a certain kind of neutrality in the internet is really pernicious and one that has no logical limit.
Can I say a couple quick things?
You bet.
I know you want to move on, but there's some important things that have been said, and I'll try to be as quick as I can because I know we're running short on time. First of all, I'm just going to go through a very quick checklist of things to react to, and I'll try not to say anything else. It was implied earlier that we had something to do with the AT&T T-Mobile merger. Both Commissioner Pai and I have really good alibis. First of all, it was never put to a commission vote, and his alibi is even more airtight. He wasn't even confirmed yet. So
Talking about John.
neither one of us had really anything to do with it. It was a staff decision. It never got to the what we call the 8th floor for commissioner vote. Wanted to set that straight. And when it comes to dual review, by the way, first of all, Congress tells me what to do. I don't tell Congress what to do, but I do think it's redundant. I think the FCC could provide an advisory role, but if I were advising Congress, and I've been asked this question many times by members of Congress, that the redundancy there is quite onerous. I just had a small company in my office going through this dual review process. It was very expensive for them, and I think this also kind of weaves into Commissioner Pai's opening remarks. When we're looking at a new statute, and I'm going to plug Randy's book here for a minute. Randy May has edited a great new book called well, I haven't read it yet, but I did read the table of contents. I read the table of contents, and they're fantastic. And Communications Law and Policy in the Digital Age, and I've seen some of the authors and the names and some of the titles of some of the chapters in it. It's fantastic. But we need to relook at this, as Commissioner Pai said, these stovepipe, if you provide a service over twisted copper pair, there's one set of laws. If it's over coaxial cable, it's another set of laws. If it's over the air one way, it's another set of laws. If it's over the air another way, it's another set of laws. From the consumer's perspective, things have changed. They want their content and their applications delivered over whatever platform it is they want. And by the way, that signal is traversing fiber and copper and coax and the airwaves before it ever gets to them. So how do you account for that? So absolutely, we need to modernize the rules. They go back certainly to the 1800s in railroad regulation, which goes back to like 17th century canal regulation. So I think this is due for an overhaul. When it comes to net neutrality, real quick, so I think it's important for folks to understand, as Commissioner Pai said, this was a rule series of rules regulating network management. There was absolutely no market analysis done by the FCC, zero. The 4 or 5 cases cited by the FCC, I think when you look at the quadrillions of internet communications every hour, doesn't even rise to the level of de minimis. All those cases were resolved under existing law. I think that's very powerful. So there's no factual need to do this. And I think having no market analysis is very powerful. What you really saw this is all about was the most common request we get at the FCC, when you boil it down to its nub, is please regulate my rival, but not me. And so when we talk about regulatory capture, actually the FCC is often presented with not regulating or not regulating an industry. It's which industry are you picking? And in this case, it's application providers and content providers who want to put costs on network operators in the absence of a finding of a concentration of market power, abuse of that power, resulting in consumer harm, which I think should be the basic 3-part test of any new statute. And then to cite investment, CapEx in networks has actually stalled out at $66 billion per year. From 2010 to 2011, it's stalled out. That's a robust number, but we want to see it go up. Don't know. We don't know. I'm going to underline that fact. We don't know if that's because of the Open Internet Order or not, but it was going up during the meltdown of 08 and 09 and leveled out. So we want to know why that is. Investment in apps and content have been going up. They were going up before the Open Internet Order. So for the FCC to try to take credit for more investment in apps is like a rooster taking credit for the sunrise. It really is. It was happening anyway. So, and then you're absolutely right, Your Honor, there is a mootness, if there was ever a factual basis to begin with, in that we have more competition in the last mile. The concept of net neutrality is a very old wireline industrial policy type mindset of one phone company and maybe one cable company serving the customer. Well, if you look at market trends, customers are walking away from that fixed static connection to the internet and moving to the wireless world. In the United States, the average American, well, not the average, over 90% of American consumers have a choice of 5 wireless carriers. plus choices of unlicensed use, Wi-Fi, et cetera. So you actually have several players in the last mile, and when you have that kind of competition in the last mile, there's a competitive disincentive to act in an anti-competitive way. Lastly, we need to be careful not to use the word discrimination. Discrimination is a dirty word in many contexts. To a network engineer, it's a good word. It means you want quality of service. If you're downloading a video, you want those video bits to take priority over your email bits. That is discrimination, and that's what consumers are actually demanding. They're actually they don't know it, but they're demanding discrimination. So in the network context, discrimination is a good thing, and that's what the net neutrality order starts to disrupt. You end up with, we have 5 FCC commissioners, you only need a vote of 3. I love all of my colleagues, but not one of us is an engineer. I think we're all liberal arts majors. So you really don't want us making engineering decisions, right? And then you start politicizing engineering and business decisions. Now I'll shut up. Thank you.
Okay. Well, that brings me to a question that I think a layperson would be able to relate to, and I'm going to ask you, Commissioner Pai. It's my understanding that there are over 3,695 pages of rules, and it has grown over 800% in the past 50 years. And it's also my understanding that Congress has specifically said in 47 U.S.C. 161B that every 2 years you are periodically charged with going through and eliminating redundant, obsolete rules and actually doing that. And I'm wondering, is it being done? I don't think so. And why not? Congress said so.
That's a great question. And one of the things I noted when I was in the Office of General Counsel, one of my tasks was to compile the reports that were required under Section 11 of the Communications Act, codified at Section 161B. And I was always amazed that so much staff time was spent tracking down all these rules, putting them together in a nice report, bundling them up, sending them upstairs where they went nowhere. And it was sort of viewed, and it continues to be viewed, as essentially a necessary administrative act that doesn't have any real importance, but Congress told us to do it, so here, we'll go ahead and do it. One of the first things I called for when I got to the Commission was to make Section 11, which is known internally as biennial review, since we review these regulations every 2 years, a really meaningful exercise in reviewing the state of our regulations. So one way to institutionalize the importance of it, in my opinion, is to require a commission-level vote. Commissioner McDowell and I and our 3 colleagues would ourselves have to sit down and look at the list, and if we determined that a regulation was not necessary in the interest of competition, which is the Section 11 standard, we would remove it, and we would explain why, and then we would transmit to Congress our determinations. And it doesn't even necessarily have to be in the context of biennial review that we engage in this exercise. One of the other things we could do is regularly incorporate sunset clauses into some of the regulatory orders that we issue, so that even if an idea is good in year 1, in year 3, competitive conditions can change. This is a very dynamic industry. And so it would be helpful for us to be forced to review those regulations as opposed to letting them sit on the books, which is why you end up with such things as the Fairness Doctrine, 25 years or so after its erasure, formal erasure, it continues to be in the CFR and other regulations like that. So I'm hopeful that we can breathe new life into Section 11 and into the rest of our rules by requiring periodic and meaningful review to determine whether they or not they continue to be necessary.
Does anyone else want to comment on that?
The FTC is under similar requirements, and we do actually have a process and have gotten rid of some rules. So that has been a bipartisan effort over the years. So it's just, but some of the rules are, frankly hilarious. The frosted cocktail glass rule, we did get rid of that one. A few others along those lines.
We have just.
You didn't know there was a rule about frosted cocktail.
We have just a few minutes. If you have a question, you may approach the microphone at this time.
I'm Frank Shepard. I'm from the provinces. I never ask a question, but I can't help myself. Okay? I'm listening to all of this about AT&T and T-Mobile and all this stuff and regulation, and going from 2 bodies to 1 body, and about consumer protection, and we have to be sure that somebody's telephone works and all that stuff. And I'm just wondering why we need even one body. You know, I guess I could see it when I was growing up with the television stations. But right now you have all these companies competing, and if something goes wrong here, I presume India's going to come in and compete, or China, or Vietnam now, I guess, something like that. And I have no problem, you know, when my car goes bad, if my car person doesn't fix it, going to the next car person. So, you know, you're worried about protecting me. Well, you all are smarter than me. I know that. You know, I can see that. That's why you all are here, and I'm in the provinces. But you all work in your own world. You know, and I'm sorry for talking. I do have a question. This is just.
Is that your question? Why do we need one body?
My question is, why do we need anybody?
Anybody. Does anybody want to answer that?
Yeah, I apologize. Why don't you all either go find something else to do or go home? Be productive.
Does anybody want to respond?
I'll just respond. Excellent remarks. A lot of merit to what you have to say. Okay. Congress sets this all up. It's the law of the land. There's a FCC. There's an FTC. We're implementing statutes, so we need to have Congress change. We can't just walk off the job. Well, we could walk off the job, but there's still going to be an agency there. So talk to your members of Congress.
I did want to mention on the consumer protection front and the antitrust front, antitrust is often an approach that focuses on competition in a way that helps make other types of regulation less necessary, because a competitive market will provide these outcomes to consumers. And then on the consumer protection front, I think generally, yes, for many, many transactions, consumers can say, hey, this didn't give me what I want. I'm going to the next provider. But there are certain things where, you know, we might call them credence goods, or things where consumers can't tell whether that really gave them the benefit that was promised. So you might have incentives in the market. And also, one of the enormous things that the FTC does, which doesn't get much discussion on panels, but is a huge part of our work, is fraud enforcement. So you have consumers that are being promised things that just aren't delivered. They just aren't provided in any way, and they lose lots of money. And there's not necessarily a market mechanism for a consumer to say, okay, I was scammed by this person, I'm going to go on to the next person. We have a lot of big frauds that come in and take a lot of money from a lot of consumers. And so we try to address those. But I agree that the basic market mechanisms are the preferred way to address most of these problems.
Okay.
Hi.
You have a question?
Yeah, and I'm going to sound like a little statement too, but to preface the question. First thing is, I'm Michael Doherty. I'm one of the few non-lawyer members of the Federalist Society. I'm the president and CEO of LabMD in Atlanta, Georgia. I am currently under FTC investigation and litigation with the Federal Trade Commission, so I assume Ms. Ohlhausen probably would have to refrain from any commentary, and I'm not really going to discuss about that. But in a general way, I shudder to sort of the debate about internet regulation even. It makes me think of what happened in Iran when all those people had their cell phones and the world could observe what was going on, and then we had crickets from DC. So when governments involve themselves in regulating communications, tread very carefully. You have a sacred duty, and I think it's critical if you're involved to not forget moments like that in the world history, especially when the world wants to do it. So when I'm in the real world, in the business world, you know, the argument that maybe judges have to have experience in certain industries to be able to actually regulate them, I find I could turn that around easily to say that people that live in government bubbles for their entire career don't know anything about business and inflict great damage when they have power and no knowledge. And so we have to bridge some more communication here because the world's getting smaller. And these things are impacting even greater. And they're not taken lightly. And they're greater than academic discussions.
So what is your question, sir? I'm sorry, I've got a line of people behind you, so go ahead.
I'm right there.
Okay.
So the question really is since you people understand that you necessarily have to be involved in government and on regulatory bodies, and I'm not against that, what self-regulation do you do so the elephant doesn't become the vampire?
Anyone want to tackle that?
I'm not in government. I'll sit back.
I mean, I'll just answer in 10 seconds, and answering just for myself, although I suspect Commissioner McDowell and Commissioner Ohlhausen might agree. Every single order that comes to my desk, I try to review through the prism of what will incent the private sector to continue to take risks, to make massive investment decisions, and if, in my opinion, what the Commission is proposing to do would create more regulatory uncertainty, would impede competition, would intrude upon the business decisions that a company owner like yourself has to make, then I won't support it. Having worked at Verizon in-house for a couple of years, I was keenly sensitive to the fact that these are regulated industries that have to incorporate the necessary evil of regulation into their business plans, but we should try to minimize that element to the extent necessary.
And ditto, as the judge pointed out in my introduction, before I got to the Commission, I was 16 years in the private sector, so, and I consider myself a temporary occupant of this position. Pardon me? So, yeah, and I'm not jealous of FCC jurisdiction. So so here to help preserve freedom ultimately. And in case I didn't make it clear, in the net neutrality order, I cast a dissenting vote. And I have a very long dissent for folks to read if you ever have insomnia.
Blair Dormany, Athens, Georgia. Commissioner McDowell's remarks about the ITU put me in mind of an agenda that was put forward in the 1970s and 80s through UNESCO for a new information order, which was, it was in the guise of a more equitable distribution of media power, but it was really a kind of a stalking horse for press regulation. And in 1984, the Reagan administration had the U.S. withdraw from UNESCO. So my question is, first of all, I'm interested who are the proponents for this expanded role for the ITU in regulating the internet. Is there an ideological agenda there? What is the agenda? And can you envision a scenario in which it would be in the U.S.'s interest to withdraw from the ITU or to curb its funding?
Excellent question, excellent statement. I love Athens, Georgia, home of the B-52s and REM and the Producers and other great bands. Anyway, dating myself there, 80s bands, all of them. We don't have to belong to the ITU. It's a matter of sort of federal diplomatic policy that we do. The ITU is a forum in other contexts for the treaties that govern satellite orbital slots. So if you want to launch a satellite tomorrow, you can't. Anyone just can't do that. You get each country has basically air rights very high up there for those types of slots. What frequencies are best for which types of uses? Like, do you want TV on the 700 megahertz band, or do you want mobile broadband, or what do you want there? So there are other issues there. And they have to be hammered out. We have border issues, let's say with Canada and Mexico, right? So how do we resolve those disputes? So it's a forum for that, but it is a large bureaucracy, and there are literally perhaps dozens of people who who sit in Geneva and read everything the FCC writes and issues. So we've got to be careful what we say and what we do. But you're absolutely right to point out. We withdrew from UNESCO. Would there ever come the day where we would withdraw from the ITU? I don't see that happening in the near term as a practical matter, but it certainly could happen someday.
I'm Sam Miorelli, and I'm wondering if the commissioners think that perhaps the net neutrality missed the point. We see since net neutrality, was sort of decided that we have some vertical integration where now the media content creators are also owning the pipes, and then we have the various rights organizations essentially creating this multi-strike policies with the ISPs. And I'm wondering if we really missed the boat here, and if the issue is not discrimination as a technical matter, but discrimination as a policy matter, where you essentially have the antitrust problem of multiple industries sort of paying each other off to discriminate on what they let their clients access, and if that's really what should be regulated here.
Does anyone want to comment on that?
I guess the fundamental question is, are consumers worse off? Do they have fewer options? Are things more expensive? Has the quality gone down? That's what you really need to look at. What is the impact of the options for consumers? That's kind of the fundamental thing you look at from an antitrust analysis. And So that would be my starting point.
I think we're going to have to, oh, did you?
And just real quickly, excellent point. Is that a UVA tie or Princeton? Can't tell if it's black or blue. But anyway, so that was one of the arguments made by the proponents of net neutrality, that somehow there would be an internet service provider cutting a deal with a content or application provider to have this anti-competitive type. You log on to Amazon.com, but it cuts over to Borders.com or vice versa, or whatever. But that's classic antitrust problem. So that's a concentration of market power, abuse of that power that results in consumer harm. So there's a solution right there, the antitrust laws.
Mr. May, last question of the day, and I invite you all to lunch at a ticketed event at 12:30 immediately following. And this will be the last question. Yes.
And I'll do it even more quickly than I planned in light of lunch being ready. And Commissioner McDowell, number one, thanks for holding up that book. I appreciate that. But aside from that, you mentioned Commissioner Pye raised the issue of consumption-based pricing or usage-sensitive pricing as perhaps an important issue facing the Commission and related to net neutrality. And you said that the engineers appreciate discrimination is not a dirty word to engineers, and it's not a dirty word for the economists either. And they're also, I don't believe there are any economists on the sitting as commissioners either, and as well as no engineers. But here's my question. I'll just focus on Jonathan Baker, because you said, and I appreciate this, you said that the net neutrality order per se does not prohibit this type of discrimination. In fact, usage-based, consumption-based pricing. And in fact, there are nods towards allowance for that. But all of the groups that, and this I think is without fail, that supported net neutrality, whenever there's a consumption-based plan that's put forward, is, they almost always really, they oppose that. And my question to you, I guess, is you said you generally can favor that because as an economist you appreciate discrimination can be good. But can you give, you said there may be examples where it's a bad thing. And I just wonder whether you can give some examples of the types of plans that you would consider not to be good under the net, not pass muster under net neutrality.
Oops. I was largely just saying that out of an abundance of caution. I didn't have anything in particular in mind. I'd have to go home and think about it. It strikes me as possible, but I don't have any example. Yes, preserving the option to, yes, exactly.
Thanks to our panelists. It was an excellent presentation by them, but we have such expertise.